You're tuned in to Agriculture Today, and we start our Wednesday show hearing from K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
Roger, talking from a recent blog article you posted titled Reselling Off-Patent Seeds, and what is an example of an off-patent seed?
Well, about 10 years ago, Shelby, the original version of Roundup Ready seeds, known as Roundup Ready 1, came off patent. And that means they were protected by a general utility patent. You couldn't save them, you couldn't sell them, you couldn't resell them, you couldn't do anything. You had to follow, you had to pay attention to the patent, follow the seed bag instructions, the label instructions, which were pretty tight on that, which prohibited the reselling of those seeds, the saving back and reselling. And of course, Monsanto, now owned by Bayer, was very protective of that. And they would have a legion of lawyers parked in St. Louis at their headquarters that would monitor the usage of these seeds to make sure that farmers were not violating their general utility patent. And so that's what it is.
And when things come off patent, what does that mean for farmers?
Well, it tends to lead farmers to believe that now they have free rein with respect to those seeds, and they can buy those seeds and plant them and save seed back and maybe buy the seed, say, on volume and resell it to farmers without any threat of any type of legal violation. And that it may be surprising to some that that's not exactly the case.
So what is the case for farmers because they don't have free rein?
Well, yeah, and it is the lower cost that's tempting for them to do this because the Generation 1 Roundup Ready seeds are typically cheaper because they're not normally bound by licensing fees. So that can help reduce input costs. But the bottom line on this is that the end of the patent doesn't mean that they're not protected. So there may be contractual arrangements. There may still be some licensing agreements. There may be other types of intellectual property protections, normally by contracts, that farmers that are looking to resell off-patent seed must be aware of. It's not to say that you can't resell off-patent seed. What I'm saying is it's possible once you check a bunch of boxes and make sure that you've cleared all the legal hurdles and are able to do so without the companies coming back at you.
What are a few of those boxes that they would have to check?
Well, one, as I indicated, a lot of these are contractually related. So even though the original patent has expired, that doesn't mean that you've got free rein to resell or distribute that seed, because those traits may still be protected by utility patent on other genetic traits. That's where we get into the stacking of traits. So the patent may have come off one trait, but the companies may have stacked traits on top of each other, and there still may be some utility patents on those stacked traits that you've got to be aware of. So and that's going to depend on the type of seed that you buy, the hybrid version that you bought. Also, there might be contractual restrictions on the seed and trademark restrictions, brand licensing agreements. And in general, as a general rule, now there are exceptions to this, but as a general rule, to sell seed in the United States legally, the seller has to be registered as a seed dealer in most states. And that seed also is going, if you're going to resell it, it's going to have to be labeled with origin and purity and germination percentage and weed percentage. And farmers that are listening know what I'm talking about. You've seen the seed bag, and that's all listed there. And that seed must also have been tested for germination, usually within the past 6 to 9 months, and be stored properly, meaning it's dry and it's pest-free, in a clean condition. So those are the boxes that have to be checked to be able to legally resell off-patent seed.
So most of the time, farmers can't buy a big bulk purchase and then sell it to their buddies to also plant?
Not unless you go through that rubric and make sure you're clear on all of those points. Yeah, you can do it if you clear all those hurdles.
What are some repercussions if they do potentially resell it and they haven't checked all those boxes?
Well, they could get threat of a lawsuit, maybe a demand letter initially from the original patent holder or the party that has some type of licensing restriction or some type of contractual arrangement over that seed that they think is being violated. They may get a demand letter from a law firm that represents them and say, look, we understand you're reselling the seed and we don't appreciate that. Here are the protections that are still on there. Can you verify that you've gotten clearance? And that's the nice way to go about it. Some firms may just say, you'll be met with a lawsuit right out of the box. Now, the one complicating factor on this is With pollen drift, the question is when seed comes off patent and you're using it, is there any purity left to it that would allow those protections contractually to still exist? And that's kind of an area that's not really been tested much in the law. And so that may cause some reluctance on the part of the companies to go full bore after protections on this. But as a farmer, you don't want to get any type of correspondence like that. And they'll put a lot of heat on farmers that are reselling seed. And so you just have to be aware that that would happen if you haven't done your due diligence to make sure that you're in the clear.
Is there also an act that was put in 1970 and was modified in 1994 that plays into all of this?
Yeah, that's the Plant Variety Protection Act. And that was, as you said, that was first enacted back in 1970. Now, that was modified in 1994. And that's what grants what we would call copyright-like protection to developers of novel varieties of sexually reproducible plants. We had the Plant Patent Act, which was 40 years earlier. That was in 1930. And then we had the PVPA. Now, the Plant Patent Act gives protection to plant varieties that are sexually reproduced. So you have one that is novel varieties and other varieties that are sexually reproduced. Now, one of the things that happened to that is that originally there was a farmer exemption. This is where some farmers get turned around on this. Under the PVPA, you could save back some seed and resell it to other farmers for planting. Well, that got changed. There was a significant court case that was decided in 1983. There was also another case that came up in the 1990s that took that one away. So you can't save and resell. You can save seed to replant your own fields, but you can't save it to resell to somebody else. So there could still be PVPA protection that's out there, even though the seed is so-called off patent. That means the general utility patent has expired on that seed. So this is an area that can get complex pretty quickly. And farmers need to be careful of thinking, well, it's off patent, I can sell it. I can buy it and resell it. Not so fast.
What if growers are planning to use a buying pool?
Well, that's a concept that's picked up some interest recently. And this is where you'd have a group of farmers that get together or seed dealers and they form a buying pool to buy off patent seed. And they collaborate to buy it in bulk quantities and get a lower cost per unit. And they get access to better quality stock or greater distribution efficiency. And then they resell it at a price that's below market price, but yet a little bit above, or at least they break even. Sometimes they'll do this for profit, a little bit above what they bought it for, but yet below market price. And so key point again is that the buying pool has to make sure the seeds were not originally purchased under a restrictive license. So again, we're back to that same issue. There may still be licensing restrictions from contracts that were attached to the original seed. You know, on that, you want to think about, for example, Monsanto's technology use agreement. That's an example of that. And the buying pool would also need to make sure that any saved or resold seed complies with state and federal seed laws. So we're back to germination standards and labeling and certification and all of that. So you've got the same requirements that would come up, plus a couple of additional ones. Buying pools also can raise antitrust and market concentration concerns. So if you've got a coordinated pool, the large seed companies might see that as unfair competition or intellectual property infringement, especially if that pool is using the company's proprietary genetics or if it's misrepresenting the seed. In other words, I'm selling it under an authorized brand name. So again, you could face the threat of a lawsuit to shut down your pool.
So what are some other options for people who are wanting to buy seed?
Well, there are places around, such as Kansas State University, that produces public domain seed. And this can be cheaper open source seed. That might be a model to look to. Look to public domain seed or this open source seed. There are thousands of varieties that are in the public domain that are bred by public universities or open source seed initiatives. And those seeds can be legally grown, saved, and resold, assuming that the basic laws, again, concerning labeling and germination and testing and so forth are complied with. And you might have another approach would be for a pool to be formed to sell identity preserved grain. That would partner with buyers that want traceable, regenerative, or region specific grain, or you form a grain buying pool, not a seed buying pool, but a grain buying pool. Another one is, we could select open pollinated lines, and then over time and space, we breed our own particular technology that's tied to cold tolerance or drought resistance, whatever it might be. Then once that line is developed, then I could sell that seed as a new locally adapted variety and get a PVPA certificate for that or form a co-op. So there are options that are out there. All of them have legal implications to it, but just simply buying and reselling off-patent seed comes with some peril. You got to be careful.
Roger, I appreciate you taking the time to join us today.
Thank you, Shelby. My pleasure.
That was K-State and Washburn law professor Roger McEowen. I will link his blog article, Reselling Off-Patent Seeds, in today's show notes on agtoday.net.